A very good afternoon to you. This is your daytime update right here on Newsroom Africa, channel 405. Now, a witness in the tribunal hearing of Western Cape Judge Hlophe, Professor Libalele Mathenjwa, has defended his interpretation of Hlophe's sesithembele kinina phrase to Justice Jafta in 2008. Mathenjwa, who is an isiZulu language expert, says he understood the phrase as saying that you are our last hope in former President Jacob Zuma's 2008 arms deal saga. Mathenjwa says he came to that conclusion based on the context of the conversation between Judge Hlophe and Justice Jafta.
What was the central issue you were asked to consider?
I was actually asked to look at the phrase sesithembele kinina, which appears on the letter that was forwarded to me as a mandate and scope of my expertise, where I had to solicit my expertise to explain exactly the understanding and the meaning thereof.
And were you also provided with material setting out the source and what was done regarding what was put to you?
That's correct. I was forwarded the material, which is actually giving the context under which this particular phrase was.
Before I come to your conclusion, there is one other matter I'd like to ask you about, and it is this. You were made aware, were you not, of a meeting on the 28th of May, 2008, between the Chief Justice, the Deputy Chief Justice, and the two judges who we are to hear evidence or be cross-examined by us later on. You're aware of that?
Yes, I am.
Did you ever receive any minutes or transcript of that meeting, which lasted about 2 hours?
No, I didn't get any copy of the minutes thereof. Hence, I made a mention of it in my report. I think it's on page 11 of my report, where I do mention the problematic area which is brought by the absence of those particular minutes.
For more on this, I'm joined by Mr. Mbekezeli Benjamin, Research and Advocacy Officer at Judges Matter. Mr. Benjamin, thank you very much for your time today. Let's look and perhaps interrogate why this matter has taken a whole 12 years in order to be heard.
Well, the 12 years is a time at which there were various challenges that were brought in court cases. There were about 14 different court cases that have dealt with this complaint alone over the period of the 12 years. And you might recall that when this complaint was initiated in about 2009, there were different rules for handling complaints against judges. In about 2011, those rules were changed, and the change of those rules was also subject to some litigation, and that has caused a lot of delay. There's also been an issue of the legal fees of the different legal teams. I think Judge Hlophe is in particular, where there was a dispute over whether the state should foot that bill or not. And so all of these have taken together have been the main cause of the delays.
The allegation here is that Judge President Hlophe has tried to influence the decisions and try to influence the outcomes made in relation to former President Jacob Zuma's arms deal case. What does this particular tribunal hope to achieve?
Well, the tribunal is dealing with a relatively narrow point. It is this. It's that Judge Hlophe is alleged to have gone to the Constitutional Court, where he met with the two justices, Justice Jafta and Justice Ngubeni, and had a conversation with them. There is some dispute about the nature of the conversations and the phrases that were used in that conversation. But essentially what Judge Jafta and Ngabinde allege is that he tried to influence the way that they will consider and decide on the case in favor of President Jacob Zuma. Judge Hlophe denies this, and he says he was merely just communicating with them and says, look, we trust you as judicial officers of the highest court in the land to come to a proper conclusion. And so that's where the dispute is about. And you'll hear you've heard evidence today, and you'll continue to hear evidence tomorrow about that meeting and the contents of that meeting.
So should it be found that indeed Judge President Hlophe was trying to influence the outcome of this particular case, what are the possible repercussions for the Judge President?
Well, if he is found to have indeed tried to influence the justices, the likelihood is that he will be found guilty of gross misconduct. And gross misconduct is one of the most serious offenses that a judge can commit, short of a criminal offense. And the likelihood is that he will be removed from office through an impeachment process.
And what would that mean for him then? Because if all things stood equal and he was basically going to remain Judge President of the Western Cape until he retires.
Well, once a judge is impeached, they lose their office. They're stripped of their office and their titles. They are also stripped of their pension and any benefits that they would have received from judicial office. Excuse me. You'll recall that judges are appointed for life. So when you're a judge, even when you retire, you still earn the same salary that you earned while you were still actively hearing cases. And so when you're impeached or you're removed from office, you lose that salary, you lose all those benefits, and basically you become an ordinary citizen like all of us.
This particular tribunal, what type of a precedence does it set for other cases and other hearings in the future involving judges?
This particular tribunal is we could say it's self-contained. Whatever issues are discussed in this particular tribunal will be limited to this tribunal. Future tribunals may not necessarily rely directly on what is said or what is found in this one. And so, in terms of precedent, perhaps future tribunals might consider what happened and the record of what happened in this particular tribunal, but they cannot directly rely on all that has been found. Perhaps if he is found guilty of this particular act of misconduct, then in future tribunals, they would simply take note of it, but they wouldn't consider it as a fact in deciding those future tribunals.
And talking about facts here, there's such a fine line. If you're listening to the proceedings and you're listening to the tribunal now, there's a question of what was said, what was intended, and then on the other side, the interpretation of what it is that was said. Very murky waters there, because you would have heard Judge Hlophe there saying that his intention was not to influence the outcome at all, but just saying that our hope is in you to do the right thing. How are they going to prove this? It seems very subjective.
Well, it does. There is an element of subjectivity to it, because you will hear that it was based on what Judge Hlophe meant when he said those words, and also what Judge Jafta and Judge Ngabinde heard and understood by what he said. And so, based on that, it's very difficult to resolve that kind of issue. But the panel, the tribunal members, when they are considering all the evidence, then they will have to weigh up what factors may be considered on deciding either way that this will go. So, for example, they'll consider the testimony that the expert Professor Muthenjwa gave today in light of the entirety of the conversation, in light of the fuller context of what was happening in 2008, 2009. So they'll have to look at the bigger picture and situate those words within that bigger context and not just in isolation.
If you could talk us through this, Mr. Benjamin, you would have seen that there are various counsels that are at the tribunal. There's Advocate Thandi Norman, who is representing both Ngabinde and Jafta, who right from the beginning were quite hesitant, reportedly, in moving forward with this particular case. And then there's also Advocate Marcus, who is representing the other judges of the Con Court. Is there a unilateral consensus among the judges that this is indeed a case that even deserves to be heard?
Well, it's difficult to say that there is unilateral consensus because all of the judges could be said to have been acting independently in laying the complaints and being complainants. But in some ways, their complaints overlap and they sort of form one unit. I think there's also a slight difference between the different judges. So Judge Jafta and Judge Ngabinde heard directly from Judge Hlophe, whereas the other 9 justices of the Constitutional Court, they heard secondhand from Judge Jafta and Judge Ngabinde. And so that the fact of that position also influences how they approach how they have approached this particular complaint. Certain of the justices have decided to go together, and they are represented by Advocate Marcus, while Judge Jafta and Judge Ngabinde are represented by Advocate Norman, I think because of their unique position in relation to the others. So I think there is some overlap, but there are some unique differences in the way that they are approaching this and the way that they are implicated in this complaint.
What ought we, you believe, to expect from tomorrow's witnesses?
So tomorrow's witnesses will be Justice Jafta and Justice Ngabinde. They could easily be said to be the key witnesses in this because they were the ones who were present in the room. So they will each be called up to testify about the nature of the meeting, first of all. They'll also testify on what was the basis of the conversation that they had with Judge Hlophe. They'll also be speak on what was said in the meeting, because as you heard from today's witness, there isn't minutes or a transcript of a particular meeting. So it will each be based on their own recollection of the events, and they will then speak about what they understood Judge Hlophe to mean when he approached them and uttered those words to them, and also what their reaction was. And so it's an important day tomorrow to look out for their testimony.
And can we expect any of the other 9 justices also to be called in to give witness?
So that was what took up a bit of time this morning, whether or not the other justices could be called. And the ultimate decision by the chairperson of the tribunal was that they might very well be called, but he doesn't want to close the door as yet, because the issue is that Justice Jafta and Ngabinde are so-called direct witnesses. So they will testify on exactly what was said to them and what they said in response. The other justices sit in a different position because they heard from the other 2, and so they could be said to be hearsay witnesses, although they may be given an opportunity to testify, but their evidence stands at a little bit of a different position in terms of how much weight could be placed on that evidence.
Well, we thank you so much for your insight in this particular matter this afternoon, Mr. Benjamin. That's Mr. Mbekezeli Benjamin there, a research and advocacy officer at Judges Matter.